Thank you, and good afternoon. Thank you for joining us for Litigation Basics, episode number 2, Dispositive Motions. My name is Stephen Reingold, and I am your moderator. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 6 summarizes this episode, and Slide 7 provides a summary of the series. Now, speaking of the slides, you should understand that we will not step through the slide deck in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the slide deck handy, however, because I will try to indicate which slides the conversation is touching on as we proceed, so you can take notes. Our panelists today are Jeff Leon, a partner at Karen, Tim Pastor, a partner at Montgomery, McCracken, Walker, and Rhodes, Adam Russ, an equity member at Gordon, Arada, Montgomery, and Barnett, and again, my name is Stephen Reingold, and I'm a partner at Saul Ewing. Now, we appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 32 through 35. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review. We thank you for your sponsorship. If you are attending the live premiere of this webinar, you could submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the episode, and we will do our best to get you an answer. Okay, with that, let's get started. So, Jeff, I'm going to start with you. Our whole reason for being in this series is to address litigation basics, begin at the beginning for our audience members. So today's subject is dispositive motions. Let's begin at the beginning. Tell us, if you would, what is a dispositive motion?
Sure. So a dispositive motion is what it sounds like. It's a motion that you make to dispose of either some part of the case or the entire case. And there are a few different types. There's one that is directed solely at the pleadings, such as a motion to dismiss, or in some jurisdictions, it's called a demurrer. There are versions of other dispositive motions directed to the pleadings, like motions to strike. And then there are later stage dispositive motions, summary judgment motions, which are directed at the evidence that has developed or not developed during the course of a litigation. So as the slide indicates, this is in the federal courts what rules are governing which particular types of motions. Every state has their own rules. Sometimes they're quite different than the federal rules approach, but usually there's a fair degree of consistency with the general rules and presumptions.
Great, thank you for that. Thank you for the reminder. We are going to be talking about procedures under the federal rules, but it is important to check your state rules for their corollaries to what we're talking about, and also any court rules that you might have to look at as well. So let's begin at the beginning of the list then. Tim, let's throw it over to you. Motions to dismiss. What is a motion to dismiss? What is it for? Why are you filing it at the beginning of the case?
Well, first of all, thank you for including me, Stephen, in this webinar, and I'm glad to be here with the other presenters. The motion to dismiss is among the dispositive motions that Jeff mentioned. A motion to dismiss, usually brought in an early stage of the case, doesn't necessarily have to be an early stage, but that's typical. And it attacks the sufficiency of the plaintiff's complaint. The complaint is deemed true on all well-pleaded facts. And the motion to dismiss argues that even if you accept those facts as true, that the defendant, presumably the one making the motion to dismiss, or it could be a counterclaim defendant making the motion to dismiss, asserts that even assuming the facts is true, as a matter of law, the complaint still fails, and the plaintiff cannot state a claim for relief. There are several different examples of motions to dismiss. So one would be if the court lacks subject matter or personal jurisdiction. These are moderately complicated concepts in civil procedure that effectively say, on the one hand, a court lacks subject matter, it doesn't have authority to hear the dispute, or a court lacks authority over the particular defendant because they're not subject to jurisdiction in that particular court. A defendant can move to dismiss on that basis. Another example is where the plaintiff asserts a claim, but the claim is time barred by an applicable statute of limitations that restricts the claim in a way that requires it to be asserted within a certain amount of time. These are usually measured in years, but not always, depending upon what the issue is. And so if you assert a claim beyond the statute of limitations, that gives the defendant a grounds for a motion to dismiss. Another example would be if you, as a defendant, are named in the case, but you don't belong in the case, or perhaps it's the wrong entity. The entity that was named is not the entity that it's at fault. Now, ultimately, if you control both entities, you may just have to substitute one for the other. But in the meantime, you would have grounds to move to dismiss on the basis that the wrong entity was sued as the defendant. Another example is where the pleading is insufficient in some respect. I'll give you a more concrete example, and that is when you allege fraud in most, if not all, jurisdictions, you've got to particularize your allegations. You've got to allege the who, what, where, when, and why of fraud. And if you don't do that, if your pleading is insufficient in that respect, that can also be grounds for a motion to dismiss. And the allegation in that motion would be that the pleading lacked sufficient particularity to establish the cause of action for fraud. That's one example under the federal rules where you do have to particularize your allegations, and perhaps you didn't. That would give the defendant a basis to move to dismiss. Another example that I'll mention as a final point is sometimes that defendants get sued, but you're missing a party. Maybe you failed to name a defendant that was indispensable. And if you fail to name that party, the other defendants can potentially move to dismiss. So those are a few examples of what a motion to dismiss could include, and again, usually asserted at the early stages of a case.
Yeah, thank you for that, Tim. So Adam, let's move over to you. And as I mentioned a moment ago, we are using the federal rules as a baseline, acknowledging that state practice, you're in Texas, your practices are very different in some regards from the federal rules. But let's stick to the federal rules just as a guideline here. What is the procedure for filing a motion to dismiss? What does the party seeking that relief have to do?
Sure. A party seeking to file a motion to dismiss has an obligation to make that motion in court before a responsive pleading is due, to the extent a responsive pleading is allowed. In other words, you have to do it at the outset of the case. There are several grounds upon which a party may move to dismiss under Rule 12. 12b sets forth, in fact, 7 enumerated ones that I'm going to talk about. The first is 12b1, a lack of subject matter jurisdiction. 12b2 is a lack of personal jurisdiction. 12b3 is an improper venue. 12b4 is insufficient process. 12b5 is insufficient service of process, different from 12b4. 12b6 is the most common. It's a failure to state a claim upon which relief can be granted, and comes up a lot in commercial litigation. And finally, 12b7, a failure to join a necessary party. That's one that a lot of people will bring up when there has been a failure by a plaintiff to bring in a party that's important to the overall proceeding so that complete relief may be granted as a matter of law.
Okay, and staying with you just for a moment, Adam. So if you file a motion to dismiss, what does that do to the overall process of the case? Does it grind to a halt? Does discovery continue? Does it depend?
Sure. I want to start out with by saying it depends, because in my experience, there are some district courts and some judges that require a responsive pleading to be made concurrent with the filing of a motion to dismiss. Now, keep in mind, that's more the rarity than the common occurrence. In most cases, when a party files a motion to dismiss, that halts the obligation to file a further responsive pleading. In other words, an answer to the merits of the complaint that were alleged. And so you have to be very careful about which jurisdiction you're in, which district court you're in, and which judge you're in front of to ensure that you don't have, per a local practice, a requirement to file that further responsive pleading. Otherwise, though, in typical fashion, the motion to dismiss that's filed essentially serves to kind of move the case, the determination, to the court's hands to determine whether or not it gets beyond the threshold of the court.
Thank you. And let me add a footnote there. So Adam is right. In some jurisdictions, Georgia, for example, Georgia state court procedure is different than federal court. If you are going to move to dismiss, you also need to file a responsive pleading. You also need to answer in order to preserve that right. Otherwise, you get defaulted even if you've moved to dismiss. That is not the case in most states, and it's certainly not the case in most federal districts. So you need to be aware of those differences. The other thing you might see is if there is a motion to dismiss for lack of personal jurisdiction, sometimes courts will allow limited discovery on the jurisdictional issue before the broader evidentiary discovery begins. So Jeff, let's throw it back to you. So let's stay with motions to dismiss. You've now filed your motion. Adam has filed his opposition. What is the court looking at? What is the standard by which the court's going to judge your motion?
So under the federal rules and in most state courts, what a court does is they're supposed to take the factual allegations and assume they're true, and then weigh those allegations against the law and determine whether those facts as stated could in fact establish a violation of that particular law. In specific application, for example, if you are a personal injury plaintiff and you're suing a government and you have to plead certain requirements to get around governmental immunity, the government will typically file a motion to dismiss and say that the facts that you've alleged don't overcome the presumptive grant of immunity in whatever statute exists. So they're very fact specific and uniquely focused on particular, areas of law. There's a million kinds of dispositive motions just in personal injury cases. In antitrust cases, you've got a whole different set. And, the different counts of the antitrust cases, involve a whole slew of different issues that could come up. So that's the basic rule. The example Steve used with regard to lack of personal jurisdiction, which is becoming an increasingly thorny problem in this internet age where people can do great harm but never actually be physically present in the particular state where the court is located. There can be some consideration of what we would call extrinsic facts. And sometimes defendants can try to bring in outside facts through judicial notice and ask the court to take judicial notice of some event which the plaintiff has omitted from their complaint. And what can happen is if you put too much extrinsic evidence into your motion to dismiss, it can be converted to a motion for summary judgment by the court, which as a defendant, you don't want that to happen because it kind of defeats the whole purpose. If you want to move for summary judgment on the complaint, you can, but that requires you to, put forth a bunch of evidence and say there's no way the plaintiffs can win even if they took discovery. They can't defeat our evidence. So, that's the basic deal with the standards. I do want to make one point since, we most of the people on here will probably mostly practice in state courts. So, among the differences, the one Steve noted, Georgia, where you have to file your answer with your motion to dismiss. Different states have different pleading standards. So federal courts are a notice pleading standard. It just requires a simple, short statement of a declarative fact. Whereas a state like Illinois is what's called a fact pleading jurisdiction, which means you have to plead not just the ultimate fact, but, the sky is blue, but you have to state why the sky is blue factually. That would be, the most simple example. And so your motion to dismiss can focus on that lack of sufficient specificity in a fact pleading jurisdiction. Whereas unless you're in the fraud context that Tim noted, before, otherwise a simple declarative statement such as the sky is blue is going to be sufficient. So you have to kind of factor that thought process into deciding whether to make a motion to dismiss and what to challenge.
Thank you for that. So Tim, let's go back to you. We talked about, what the court's going to look at, what Jeff described, taking the facts as alleged is true. Is there a plausible claim for relief here? But what if you are the moving party and all the facts you need for your motion to dismiss are in the possession of the other side? What do you do when you don't know what you don't know?
Well, that is a challenge because allegations are assumed to be true if you're the moving party and there's certain things that you don't know. Then it is hard to make the allegation before you get into discovery. And it's important to note for those listening in and viewing this webinar that motion to dismiss, as I noted earlier, are often at the early stage of a proceeding. So to Stephen's point, there may be things that are knowable, but you don't know them yet because you haven't proceeded to the discovery phase of the litigation, which is the litigation phase where you get documents and testimony and other evidence that could be used for purposes of a motion. But I also want to make the point in kind of in reverse, Stephen, because sometimes the issue is a plaintiff who's actually asserting claims in a complaint who suspects certain issues or facts exist but doesn't have access to them yet. And in that circumstance, a plaintiff may be able to plead upon information and belief, which is a common phrase used in pleadings to suggest that you don't have direct evidence of the alleged fact, but you have reason to believe that it's true and you have a good faith basis to believe that it's true. And so you can plead upon information and belief. Our slide, for example, talks about a circumstance where a plaintiff in a small business believes that its competitors are conspiring to drive out the small business from the market, and it wants to allege the depths of their conspiracy, but it can't possibly yet know what the competitors discussed. And so it can plead upon information and belief based on certain peripheral conduct that the competitors met, colluded, conspired against them. And ultimately, if the case proceeds and to discovery and additional facts are gathered, you can amend your complaint to assert those additional facts to take what was a tentative allegation made upon information and belief into a more direct allegation, asserting more detail in your facts. In fact, I have a case in Chancery Court in Delaware right now where we've just filed a motion to amend with a corresponding amended complaint, and we've conducted months of discovery that has yielded a number of key and salacious allegations in this restrictive covenant case that show the depths of our adversaries' solicitation of our employees and our customers. And we've pleaded those in great detail. in the amended complaint, but we're not in a position months ago to do that in our original complaint.
Right. No, that's very helpful. Adam, let's close out motions to dismiss with a question. So you've moved for dismiss to dismiss, and the court has denied your motion. What next? Do you get to try again?
Well, if a motion for dismiss has been denied, then what you do is you proceed to discovery, and you can get to try again to have the case dismissed, but on a different standard. You can do a couple different things. You could try to do judgment based on the pleadings, or you can move for judgment as a matter of law based on what's known as summary judgment.
Okay, and let's take the converse. What if the motion to dismiss is granted? What does the plaintiff do?
Sure, tough spot.
Yeah, go ahead. I'm sorry.
Tough spot for a plaintiff to be in. Where a motion to dismiss is filed, the non-moving party, if you see that looks like a meritorious motion to dismiss has been filed against you, and the train's coming down the track, you have an opportunity under Rule 15A to amend as a matter of right within 21 days. So you can essentially say, well, before the court grants this motion to dismiss, I've got a chance to kind of add some additional allegations that would make it so that this thing doesn't get granted. Courts typically will grant at least one opportunity to amend a complaint to a plaintiff to avoid that dismissal right out of the gate. Now, if a dismissal is granted without prejudice, a party can typically refile, subject to there being running of a statute of limitations period. But you should also note that parties can't just go ahead and refile or amend to the extent that an amendment is futile. In other words, if it's not going to change the overall merit of your allegations, it's not going to work.
Right. And judges are pretty attuned to that. All right,
Right.
let's move on to sort of the second bucket here, Jeff, which is the motion for judgment of the pleadings. What does that look like, and how does that differ from a motion to dismiss?
I mean, honestly, not that much. I mean, the difference is that you can look at, the answer as part of the motion. But, the answer doesn't usually add a whole lot. Because an answer in almost every jurisdiction, including federal court, you simply admit an allegation by saying admitted, deny an allegation by saying denied, or stating you lack sufficient information to admit or deny the particular allegation. Now, you can raise affirmative defenses in your answer, such as statute of limitations, and then you could put facts in that, almost like a complaint, and then that can be a basis for judgment on the pleadings, more on the affirmative defense side. But usually you have enough to do that from the way it's been pled for, to do it as a motion to dismiss. So, that's an important consideration. I want to throw in just one practical thing, which we haven't talked about in relation to the leave to replead. Like, there's almost always a bunch of technical motions to dismiss you can make to a complaint. What you really have to think about is this a good use of your time if you're on a contingency, or a good use of your client's money if you're being paid by the hour, to file a motion to dismiss that is, is easily correctable. That's one thing. Another thing is, you may look at a complaint and see that it's really clear that the other side doesn't actually understand what the law requires them to plead. And that may mean they also don't know what to pursue in discovery. So you got to think about whether you want to educate them by filing your motion, which then makes them look at the law, which makes them plead a proper complaint. And then they know, oh, wow, I'm really going to have to do discovery on that thing, which I had not pled in the first instance. You may be messing yourself up down the road. So just because you can, like many things in life, doesn't mean you should. And, that's just one, I think as a young lawyer, you may get all excited because you get a complaint and you see it's defective in a bunch of ways and you want to rip off a motion to dismiss. It's good to take a breath and think about, the practicalities in the long view.
All right. So Tim, let's pick up on that thread. So, Jeff makes a good point. As a young lawyer, you're eager to, win every battle and bring every battle. Is there a time when you want to hold your fire at the early stage of the case where you wouldn't file a motion to dismiss, even if you could, perhaps other situations than what Jeff has described?
Yeah, I agree with what Jeff stated about how it's not always advantageous to bring a motion to dismiss. We have to operate within certain practical realities. And the fact is, litigation is very expensive. And there are all sorts of different types of clients. Some clients have the wherewithal to file every motion and raise every argument and take the case all the way through trial. And other clients have to be more cost sensitive and factor that into their strategy. A motion to dismiss is not an expensive process, depending upon what you're arguing. So there may be times where, just as a practical matter, you don't bring the motion. Other times, as Jeff pointed out, you don't bring the motion because the defect that you're going to raise in your motion is easily correctable. And it may be a defect that you want to address and exploit later in the litigation. If it's apparent to you, but not your adversary, there may be some benefit to deferring on the motion. However, I want to present a counter argument to some of the points that Jeff made, all good points, but just something to think about. Almost every motion to dismiss that I have made, even where I had a limited chance of success, I gathered intelligence from my adversary or from the court. So I'll give you an example. Going in on a motion to dismiss a particular complaint in a New Jersey state court, and the judge held a hearing, which some judges do on dispositive motions. Some judges always do it on dispositive motions. Other judges don't. This judge held a hearing, which means we got to discuss some of the issues that were broader issues in the case, even if they weren't at the forefront of the motion to dismiss. And the judge offered his views of some of the theories and some of the underlying alleged allegations, and mapped out for us, perhaps unknowingly, what was important to him, what wasn't important to him. So it was an intelligence gathering exercise. And that particular matter, and this has happened in other matters, but we lost that motion. The client had an expectation we would lose that motion, but deemed it worth the expenditure because of the intelligence that we gathered from the judge. So yes, there are times you have a basis for a motion and you decide not to bring it. And then there's times where you have a basis, might not win, but you bring it anyway because of the intelligence that you gather in the process.
Excellent point. So we're about halfway through. So I want to save the rest of our time for the most complicated of the motions, the dispositive motions, the ones that require the most work and the most thought, and that's a motion for summary judgment. So Adam, let's go back to you, just from sort of a high level before we get into the details in the rest of our discussion, just at a very high level, what is a motion for summary judgment?
Sure, motion for summary judgment, Rule 56. Keep that in mind. It's an important rule. It's one that if you're practicing in federal court or in states that have similar practice to the federal courts, it's one that you're going to need to know. It's very important. Why? Because a motion for summary judgment allows a court to go in and to grant judgment in favor of the moving party on either one or potentially all of the claims or defenses raised in the case before a trial on the merits actually occurs. Now, this can be very important strategically for a number of reasons. It can whittle down the number of claims and defenses that are at issue when there is ultimately a trial that's held, or it can obviate the need, the time, and the expense of having a trial altogether. Now, these motions for summary judgment, they can be filed anytime up until typically 30 days after the close of all discovery under Rule 56B. There may be some different practice given special circumstances in certain cases. That's typically spelled out in a case management order. And these motions can be filed during or after close of fact discovery.
Okay, so Jeff, you made a point before I want to circle back to, sometimes, there's so much in your motion to dismiss, the court will convert it to a motion for summary judgment. How does that happen, and what happens to the opposing party, and what does it get to do?
Well, the opposing party gets to bring in evidence, and they can actually move under another subsection of Rule 56 for leave to take discovery to respond to the motion. Now, just strategically, that may be, as Adam noted, you can bring a summary judgment motion really at any time, up until 30 days after the close of discovery. You could do it as soon as you get the complaint. And what that does is it changes the onus of taking discovery significantly, right? We have, the rules that govern document requests and depositions and interrogatories. They're not predicated on need. Well, the summary judgment rules, if you want discovery before you have to respond to summary judgment, you have to be specific, you have to file a declaration, and you have to articulate a substantive need for the particular types of discovery that you want to take for the judge to grant it. So it really dramatically narrows the type of discovery that you can take. So it gets tricky, but I hadn't really seen it a conversion to summary judgment since the federal courts, and I know I'm jumping ahead a little bit, but since they've converted what used to just be a simple brief, with a bunch of exhibits attached, into this detailed required charting that you have to state your undisputed fact and cite to specific parts of the record, and then it's all attached. Obviously, you don't do any of that with a motion to dismiss. So if a motion to dismiss is converted to summary judgment, I would imagine the court would tell the defendant to go back and actually file it as a compliant summary judgment motion under, Rule 56, because on its face, it's not going to be a compliant summary judgment motion if it's filed as a 12B motion to dismiss.
Right, and of course, the non-moving party is going to have the opportunity to put in its countervailing evidence to show there are genuine issues of material fact.
Right.
Disputes. So
right. But as to the question on the standard, the big difference is before, with the motion to dismiss, you take the fact pled as true. Now you don't take the pleading as true at all, because the pleading is not a fact, it's not evidence, right? Instead, you have to take the evidence as true and determine if there is a dispute in the evidence. The role of the judge at summary judgment is not to decide the dispute. It is to identify whether there is a dispute. And if there is a disputed issue of fact that is material on a given point, then it has to go to trial. And that is, the crucial significant difference. It's all based on evidence, and the evidence has to be admissible evidence. So you often have a battle at summary judgment, and I know we're going to get to that, I'm foreshadowing it, over whether the evidence that you claim establishes a disputed fact is actually evidence you can rely on.
Right.
So.
Right. So let's break down. You referenced the standard. I have it up on the screen for those of you following along at home. The standard is in Rule 56. Motion for summary judgment is granted if the moving party demonstrates there are no genuine issues of material fact and judgment is warranted as a matter of law. So we're going to break that down because that's a really important standard. So Tim, let's go back to you. So the first part of that, there's no genuine issue of material fact. What does that mean?
Well, it's code word for honestly disputed issues between the parties. So a lot of young lawyers that I mentor in the course of my work will confuse when an adversary objects to or challenges an allegation. That's not enough to make it a genuine issue of material fact. And I've had circumstances where we brought a summary judgment motion, our adversary files an opposition and they dispute something, but they have no basis, no genuine basis to dispute it. It's quite easy to say, I disagree. Well, it requires more than a mere disagreement over an alleged fact that is supported by evidence. You then have to raise a genuine issue to the fact finder. So there are a couple of categories where this is actually easier to do. I'll give you two categories as examples. Credibility almost always creates a genuine issue of material fact. If you're a plaintiff's lawyer and you can contrive or earnestly allege credibility dispute of some kind, you've got a greater chance of surviving a summary judgment motion because you've created a he said, she said circumstance that a fact finder has to sort out, and they can't render a decision as a matter of law because they have to assess the relative credibility of he versus she. Another example is where someone makes a fraud allegation, and fraud requires that you demonstrate that someone acted with a certain intent to deceive. And determining that they had that intent goes to their state of mind, and their state of mind is often a function of surrounding facts and can create fact issues. But I want to reemphasize my first point, because even in credibility determinations and even in allegations of fraud that go to the state of mind of a particular litigant, that doesn't mean that those are genuine issues. So I really must emphasize that as a key word in this phrase, genuine issue of material fact. Because that word, if it wasn't there, then defendants could survive summary judgment in every case because they would just dispute things, but wouldn't have a genuine basis for doing it.
Excellent points. And I know, one of the fun things about these webinars is we all have, really crystal clear examples of cases where these issues arise. I have a couple swimming around here, but in the interest of time, I'm going to move on. Adam, let's go to the second half of the standard, which is judgment is proper as a matter of law. So, you filed your motion, you have demonstrated there are no genuine issues of material fact. What does it mean to ask the court to find that judgment is proper as a matter of law?
The easiest way to understand is to the extent that the facts are A, B, and C. The court looks at what the applicable law is and says, as a result of A, B, and C, what must result? In other words, must I render judgment in favor of the plaintiff? Must I render judgment in the favor of the defendant? Or must I take an alternative approach, deny everything, or deny some in part and grant in part? So it's an evaluation of what the law, as applied to those undisputed facts, requires.
Now let's get into the fun part, which is actually preparing the motion for summary judgment. And I'll put the word fun in quotation marks because I think all four of us would agree it's not easy to properly prepare a motion for summary judgment with all the supporting evidence. So Jeff, let's get into that. So let's start, you're the moving party. What is it you have to do? What are you submitting to the court? It's not just a 2-page motion. What is it?
It's, even in simple cases, it can be an enormous pile of material that ends up getting submitted to a court. And so it usually, starts with a legal brief. You got to write your brief, citing the law and discussing the facts in your supporting what's called statement of undisputed facts. And that statement is usually required to be in the form of a chart where you state your fact on the left side with your citations, and then there's a place for the plaintiff to respond and to say it's either undisputed or that they dispute it and state the basis for disputing that fact and where in the record that disputed other side of the coin fact exists. And it can come from documents produced in discovery. It can come from deposition testimony, and it can even come from affidavits of witnesses who didn't testify. And your average case, you're going to at least usually have 3-4 depositions, a bunch of documents, and, you may go out and collect some affidavits. And by the way, if you're using an affidavit from a witness you didn't even know existed, you're probably going to be able to get leave to take the deposition of that person. But if that person was on some witness list and you never deposed them, and discovery's over and they come up, the other side comes up with an affidavit from that person, you may be out of luck. But that's how it's all fitted together. So I've seen in very simple breach of contract cases where it's just a breach of one clause, and I've seen thousands of pages of materials submitted to the court electronically, and the court then has to go through all that. And by the way, one point I want to make is we've been talking about this like it's a defendant thing. A plaintiff doesn't make a motion to dismiss their own complaint, but a plaintiff can make a motion for summary judgment, saying they ought to win as a matter of law without the need for a trial because the defendants have failed to establish a material, genuine issue of fact. So, it's important to keep in mind that this is a tool that's available to plaintiffs as well. Steve, you're on mute.
You'd think by now I'd figure that out. We talk a lot about reminders. I want to make another one that we've made before, but it's important to make again. When you are moving for summary judgment or indeed filing any motion, if you are in federal court, check your district court's local rules and check if your judge has particular courtroom rules, because that will dictate what you need to do to properly submit your motion. Same thing with state courts. If you have, a different standard, a different rule, additional obligations, make sure you satisfy those as well. So, Tim, let's go back to you. So you're now opposing a motion for summary judgment. What is it that you can put forward to the court to say summary judgment is inappropriate at this time?
Well, your principal goal is to raise a genuine issue of material fact. But you also may be able to attack the facts upon which the motion is based as insufficient or defective in some respect. I'll give a few examples. So if the moving party supports their motion with an unsworn statement, for example, of a witness, that's not sufficient. Statements typically supporting affidavits, for example, have to be sworn. And if there was just some unsworn statement offered up for purposes of the motion rather than existing as a separate, independent piece of extrinsic evidence, but a motion, an affidavit or a statement that is prepared but unsworn, that's not going to be good enough. Other evidence may be inadmissible. Perhaps there's a key fact alleged in an affidavit that is ultimately inadmissible hearsay. A court can deem that that's insufficient for purposes of rendering a summary judgment in favor of the moving party. So you can attack that evidence. Perhaps the evidence is insufficiently authenticated. So there are various ways to authenticate evidence. The typical practice, and I've had the privilege of appearing in many different states, and typically you will either attach your exhibits to an authenticating affidavit or declaration or certification or other sworn statement of a client representative, or it could be the attorney. New York State, for example, it's very common that our exhibits are submitted through an attorney's affirmation. That's mostly for expedience, so that all the exhibits are in one place, and perhaps the separate client affidavit refers to them and authenticates them. But in the absence of those things, then you can argue that the moving party has not sufficiently presented evidence to warrant summary judgment. I'll give you another example of something where we have an authenticity issue. We are currently moving for summary judgment on a case in New York where we have a voice recording. Well, ultimately we could play that at trial, but it's hard to play a voice recording when you're submitting written papers on an electronic docket. So again, it's feasible, but what we've done is we've had a transcription company transcribe the audio recording and then sign a verification attesting to the accurate nature of the transcription. And we will then have one of the two parties that were on that phone call attest that he placed the call, that he recognizes the opposing party's voice, and that this is a call that occurred on a particular date at a particular time. So in the absence of that, if we just offered up a random transcription, potentially the party opposing our motion could argue that that evidence is insufficient for purposes of summary judgment. So that's a good example of authenticating your evidence. And if you fail to do it, you give the opposing party an angle to challenge your motion.
No, those are excellent points. I've got a similar issue in a case in Georgia now where an affidavit in support of a motion for summary judgment attaches a screenshot of a non-party's website, and they're relying on that. And I had a whole laundry list of objections as to why that is not admissible evidence and why the court can't rely on it in support of summary judgment. So, Adam, knowing that and hearing all the things Tim is going to do to pick apart your evidence when he sees your motion for summary judgment, as you're moving through your case, before you ever get to your summary judgment motion, as you're prepping your discovery, what are you thinking? What are you planning so that you can fend off Tim's fights?
Sure, Stephen. I think there are two tools that I tend to rely upon in my toolkit more often than anything else as I work through a case. The first is a timeline of the key critical events that's supported in another column with the key critical evidence that relates to that event. And I keep track of that as I go through a case, as I go through the discovery phase of receiving in written discovery responses, documents that have been produced, and taking depositions so that I can better understand exactly how everything unfolded and what evidence, documentary or otherwise, I might be able to use in my future briefing. Second tool that I rely upon a lot is to give my best effort to put together a really strong outline that I'm going to use for my motion for summary judgment. In other words, I'm on the defense side. What are the plaintiff's claims? What are the elements of each claim? What are my affirmative defenses? How am I going to challenge their claims? And I use that and I fill that in with the evidence that we've listed out in our timeline so that as I move through and work through, my motion for summary judgment almost starts to write itself, at least in the facts section, so that I can then apply that in the law and argument section of the motion itself.
Great. All right, so we're about 12 minutes left or so. Let's continue with summary judgment. Jeff, I think you made this comment earlier. I want to circle back to you. If it wasn't, I apologize. But there was a mention made of partial summary judgment or not all of the claims. So, can a party seek partial summary judgment?
Yes, Tim was actually the one who was discussing that. But yes, you can winnow down the claims for trial by getting rid of some things. And that can be very tactically important. For example, if one particular claim carries with it attorney's fees, if the plaintiff wins and you get rid of that before trial, you reduce your exposure and you increase the chance that you can maybe get a settlement before trial, because now the plaintiff knows they won't be able to hold out for the possibility of getting an enhanced attorney's fee, or a claim that carries with it punitive damages, if you can get that dismissed. Sometimes people actually try to move for summary judgment on punitive damages, saying that the evidence cannot rise to the appropriate legal standard. So you have to consider what your goal is in undertaking summary judgment. Like I mentioned before, and Tim and I were discussing the pluses and minuses that are completely divorced from, the legal merit that you have in making motions to dismiss. You have those same considerations with regard to summary judgment. The monetary point I made before is like multiples of what the the cost in terms of time in hourly legal fees for filing a summary judgment motion. So if you're going to file one, you should be pretty clear-eyed in what your goal or objective is. Usually narrowing down a case is valuable, not so much for the evidence you have to put on at trial, because usually claims are significantly overlapping in evidence, but sometimes they're not. Sometimes they're just completely distinct factual matters. And so if you can get rid of that, you can narrow your trial down. Some issues may be much more embarrassing if a jury were to hear it, but yet not really have a lot of legal merit. And you may want to get rid of those so that they won't have a good excuse to bring those issues up at a jury trial. So, these are all important things to really think about. You can move on a claim. You also can move on damages, right? So the distinction between liability and damages, you could say they haven't proven their damages claims. And one of the admissibility points on evidence that we talk about is, Tim talked about a bunch of them dealing with authenticity of the evidence in the record, but there are a lot of other objections, like you can't rely on hearsay. You also, if something requires expert proof and you put in an expert report, you can challenge that expert report as being inadmissible. And therefore say, well, the plaintiffs put in a damages report that did all these calculations, say valuing high rise in downtown Chicago. And you can say that valuation didn't meet the standards of the profession. And therefore, judge, you can't consider it. It's something we call a Daubert motion. And if you can get the damages, the basis for damages knocked out, right? They had one valuation of the building. If that gets knocked out, they have no way to prove the building was worth any specific amount, and therefore they can't get damages. You can win the whole case by essentially knocking out the damages claim. So that is important to think about. Not just the liability part, but there's a damages part as well.
And just a reminder on that before we move very quickly to our last topic, in the interest of time, the group has made the point earlier that sometimes a plaintiff might move for summary judgment. So too, a plaintiff might move for partial summary judgment just to get an early win on some of the claims, and that does affect the rest of the case. So in the few minutes we have left, and panelists, I apologize, I'm going to move forward through our outline. I want to jump to judgment as a matter of law. Because that is our last type of dispositive motion. I want to make sure we at least touch on it. So Tim, let me throw this to you. So just very quickly, what is a judgment as a matter of law? And if you were representing the plaintiff and you suspect, you might be faced with a judgment as a matter of law, what is it that you were thinking and doing?
Well, you're thinking about the evidence and whether it rises to the standard that is sufficient for a finding of liability. And of course, defense lawyers always think that it doesn't. And so in that circumstance, making a motion for judgment as a matter of law can be done at the trial. The motions we've discussed thus far have been pretrial motions. Motion to dismiss we focused on early in this presentation, and then we emphasized the intricacies of a motion for summary judgment. Those are pretrial motions. If a party has addressed the evidence in a jury trial and the plaintiff has presented their case, and you believe that that you've got a basis to get judgment as a matter of law, you can make that motion. It's not a pretrial motion anymore, to distinguish it from those that we've already discussed, but you would argue that a reasonable jury does not have a sufficient evidentiary basis to find for the plaintiff on a issue or all the issues in the case. And so if the court agrees with you, they can grant a motion for judgment as a matter of law against the plaintiff on a particular claim. or all the claims, or can be on a defense. For example, there are things known as affirmative defenses, where a defendant raises these defenses and has a burden of proof on the defense. If the defense has not been properly asserted based on admissible evidence to support the defense, you could actually move for judgment as a matter of law on a defense too. That's a less common circumstance, but is procedurally appropriate where warranted. So these types of motions can be very useful if the plaintiff hasn't met their burden or a defendant hasn't raised sufficient evidence to support their defense.
Okay, so Adam, I'm going to throw a question at you, and then I want to save some time at the end for all three of you to give any final thoughts. So if you're representing the defendant, plaintiff has put on its case, are you just automatically filing a motion for judgment as a matter of law, or are there other considerations you're thinking of as to whether you might not want to?
That's one with where the proverbial "it depends" comes up a lot, Stephen, right? Because you have a consideration of the practical effect of it and the cost and the time involved. But there are situations where a judgment as a matter of law under Rule 50 is more than just routine or reflexive. It can be used in a couple of circumstances that I think come to mind. The first is where the plaintiff has failed to meet its burden of proof on an essential element of its claim. Filing a JMOL can be done in that situation as a tactical move to try to end the case before it actually gets submitted to the jury for a final determination. So here, by arguing that the evidence that's been presented in the case in chief by the plaintiff has not been sufficient to support a verdict that would ultimately be rendered by the jury in its favor, and that no reasonable jury, in fact, could ever reach any different conclusion ever, the defendant in that circumstance, your client, can seek to avoid the time and expense and ultimate uncertainty of what the jury is going to do should the case proceed to a jury determination. Second circumstance would be that filing a judgment as a matter of law motion under Rule 50 can also serve to protect the record, protect legal issues for appeal, which in many cases can be very important because some cases just need to go up on appeal for further determination. So in this circumstance, if a trial court has heard and denied a JMOL, then the case proceeds to a jury verdict. But the good news for the defendant in that circumstance is that you, on appeal, can raise that denial of the JMOL as a matter of law, further preserving those issues for the appellate court's next set of eyes to look it over again.
They're all excellent points. Everything we've heard today are excellent points. I want to close with a few more excellent points. Just final thoughts from each of you. Jeff, let's start with you. Final thoughts about dispositive motions.
Sure. In case you can't tell from what I've said, there's a lot of art and judgment that goes into the filing of dispositive motions that you only learn from doing and practicing. And so, since this is directed at younger lawyers, ask your older lawyer why they are or aren't filing one. Learn those practical considerations. Learn how your client interfacing deals with that. That's my final thought.
Excellent advice. Adam, any final thoughts?
Sure. With summary judgment motions in particular, an adage comes to mind of being penny wise and pound foolish. I had a former colleague once tell me that she never files summary judgment in the state court here in Harris County, Texas, just as a matter of practice because, quote, it never gets granted. And my thought was, well, you don't know unless you try. And the next time it came up in a case, sure enough, convinced her that that was the best course to take, that the client should spend a little money here to see if we can get rid of some or all of the issues before this thing goes to a jury trial. And sure enough, the judge agreed. And we were able to avoid that uncertainty of a potential jury hearing bad facts in the case, and we're able to resolve it favorably on behalf of the client. So by convincing a client that there are circumstances where you need to spend that money and make that investment, these motions can help your case and help your client's litigation strategy.
And Tim, final words of advice for our audience.
Yes, one of the privileges that I've had in my career is to work with very smart people and like you all. And one of the great and rewarding aspects of motion practice is deliberating with your colleagues on strategy. These motions can be quite simple, but they can also be very complicated. And when they're complicated, there's a lot of strategic considerations that are behind the making of the motion. And so my suggestion to those learning more about this process is that if you're in a position where you're practicing law in a law firm and you've got trusted colleagues with whom you can confer about these types of motions, there's no better thing that you can do for your client than engage in that level of sophisticated deliberation. Ultimately, the client is well served by conferring with your colleagues, coming up with a joint strategy, and then advancing it in the best interest of the client with the court.
Those are all excellent practice pointers. Appreciate them very much. Looking at the clock, we are now just past the hour. So this will conclude our webinar. I want to thank everyone for joining us. We hope you found this entertaining and educational. And on behalf of Financial Poise and our panelists, thank you today. Goodbye.